Hello and welcome to Courts Today. I am Urvashi Chauhan with your daily roundup of legal updates from across the country. In today's bulletin, we will bring you major legal updates from across the country, from a PIL in the Supreme Court after the deadly Air India crash, to a human rights case arising out of the post-Pahalgam deportations. We will also look at the Supreme Court's strong remarks on a bail order being ignored by jail authorities in Ghaziabad, a dowry death conviction where military service failed to earn leniency, and a CLAT-PG aspirant's legal fight over counselling fees. Lastly, we will cover the Delhi High Court's intervention in tackling monsoon waterlogging near AIIMS. Let us get started, but before that, make sure to subscribe and hit the bell icon. Following the tragic Air India plane crash in Ahmedabad on 12th June, which claimed 270 lives, a public interest litigation has been filed in the Supreme Court seeking urgent safety measures across the airline's operations. The PIL filed by Advocate Ajay Bansal urges the court to suspend Air India's entire Boeing fleet until comprehensive safety and security audits are carried out. It also calls for similar surprise audits across other commercial airlines operating in India. The petition urges that key aviation laws, including the Aircraft Act 1934 and the Aircraft Rules of 1937, are not being followed properly. It demands that safety audits be made public and that airlines face penalties for violations. The petitioner also claims that Air India has repeatedly failed to maintain proper safety standards. Citing a DGCA report, the PIL accuses the airline of falsifying internal safety audits. To support his claims, the petitioner recalls his own experience on a May 20th Air India flight from Delhi to Chicago. Despite traveling in business class, he says the seats were faulty, in-flight entertainment was non-functional, and the air conditioning system was poor, and that a complaint yielded only a nominal compensation of 10,000 rupees. The petitioner further argues that the June 12th crash of the 11-year-old Boeing 787-8 aircraft is not an isolated incident, but a result of long-standing negligence, regulatory lapses, and a safety culture that puts convenience over passenger welfare. Let me also tell you here that 2 doctors have also written to the Chief Justice of India urging the court to take suo motu action. Their letter requests the Supreme Court to direct the central government to provide prompt compensation to the victims' families and to order a thorough probe into the cause of the crash. The Supreme Court is yet to take up the matter for hearing. Stay tuned with LiveLaw. In the aftermath of the tragic Pahalgam terrorist attack on 22nd April, where 26 lives were lost, tensions between India and Pakistan escalated sharply. The incident prompted a strong response from the Indian government. As part of its security measures, the centre revoked 14 categories of visas granted to Pakistani nationals, including business, conference, visitor, and pilgrim visas. The Union Home Ministry ordered all Pakistani citizens in India to leave the country by 29th April. Following this, Union Home Minister Amit Shah personally contacted chief ministers of all states, directing them to ensure that no Pakistani national remained in India beyond the deadline. Once the deadline passed, law enforcement agencies across the country initiated the physical deportation of Pakistani nationals, escorting many to the Atari border in Punjab. It is in this context that the case of a 63-year-old woman, Rakshanda Rashid, came to light, raising questions about human rights, procedural fairness, and the humanitarian obligations of the state. She had been living in India for nearly 4 decades on a valid long-term visa and was deported to Pakistan. Her family, shocked by the sudden deportation, approached the Jammu and Kashmir and Ladakh High Court. Her daughter Falak Zahoor filed a writ petition stating that Rakshanda has no one in Pakistan to take care of her and is suffering from multiple health issues. Her husband Sheikh Zahoor Ahmed said that she had lived most of her life in India and considered it her home. The High Court took note of the exceptional nature of facts and circumstances in this case. Justice Rahul Bharti observed that deporting a person with a valid long-term visa without a proper deportation order and without considering her medical and humanitarian condition raised serious concerns. The court further emphasized that human rights are the most sacrosanct component of a human life, and in rare and urgent cases, constitutional courts must act immediately. Calling it an SOS-like situation, the court directed Union Ministry of Home Affairs to bring back Rakshanda to India. The matter has been posted for further hearing on 1st July, when the court will examine the compliance report and will decide the next steps. Moving ahead, the top court today expressed strong displeasure after it was informed that an accused in a Ghaziabad Ghaziabad case had not been released from jail despite a clear bail order passed by the apex court nearly 2 months ago. The accused was granted bail by the Supreme Court on 29th April this year in a case under Section 366 of the IPC and Sections 3 and 5 of Uttar Pradesh Prohibition of Unlawful Conversion of Religion Act 2021. For your information, Section 366 of IPC deals with kidnapping, abducting or inducing of a woman to compel her for marriage or illicit intercourse. It's a cognizable, non-bailable offence with punishment up to 10 years of imprisonment and fine. Following the bail order, the trial court in Ghaziabad had issued directions to the jail authorities to release him, provided he wasn't required in any other case. However, the petitioner has now approached the Supreme Court again, stating that the jail authorities refused to release him on the ground that a specific subsection, that is Clause 1 of Section 5 of the 2021 Act, was not explicitly mentioned in the bail order. A bench of Justices K.V. Vishwanathan and N. Koteshwar Singh called this development a travesty of justice and a ridiculous situation, observing that a citizen's liberty cannot be denied due to such technical excuses. Sensing something suspicious, the court said that if the allegation is true, contempt proceedings may be initiated against the superintendent of Ghaziabad jail, and that DG Prisons Uttar Pradesh must appear via video conferencing. The court has also directed the personal appearance of the superintendent in court tomorrow. At the same time, the court cautioned the petitioner, warning that if his claims are found false or if he is being held in another case, serious consequences will follow, including cancellation of the bail order. Justice Vishwanathan made it clear that liberty is not a matter of formality. If a subclause is the only reason for continued detention, the court will act. But if this is misrepresentation, there will be consequences. The matter is now listed as the first item for hearing tomorrow. Stay tuned. Moving ahead, the top court today refused to grant relief to a man convicted for the dowry death of his wife, rejecting his contention that he served in the military for over 20 years as a Black Cat commando and had taken part in Operation Sindoor. A bench of Justices Ujjal Bhuiyan and Vinod Chandran was hearing the man's plea, challenging a Punjab and Haryana High Court order that upheld his 10-year jail sentence under Section 304B of the IPC, which, as you know, deals with dowry deaths. He had also asked the top court to allow him to stay out of jail while his case was pending. When the court showed no interest in granting this exemption, the man's lawyer said, and I quote, "I am a participant of Operation Sindoor. For the past 20 years, I have been a Black Cat commando posted in Rashtriya Rifles." However, Justice Bhuiyan firmly responded to this, saying, and I quote, "That does not give you the right to commit cruelty at home. This only shows how physically strong you were, which helped you strangle your wife." He also pointed out that this was a very serious offence and not a minor crime where exemptions from jail are considered. Justice Chandran added that the High Court had already rejected the man's appeal against his conviction, and now the Supreme Court was only looking at whether to admit the case. The lawyer for the convict argued that the only allegation was a demand for a motorcycle and that the witnesses were closely related to the deceased and unreliable. He claimed that he could show that their statements were full of contradictions. Despite hearing the argument, the bench refused to allow the man's prayer for exemption from surrendering. However, when the convict requested time to surrender, the court gave him 2 weeks to do so. Also, it issued notice on the SLP returnable in 6 weeks. And the next update is regarding a petition filed by a CLAT-PG aspirant who was unable to participate in the admission counselling process due to high fees charged. The Delhi High Court has issued a notice on his plea challenging the high counselling fees charged for admissions to CLAT-PG for postgraduate courses. Vacation Judge Justice Rajneesh Kumar Gupta sought responses from the Consortium of National Law Universities, the Bar Council of India, and the University Grants Commission. Let me tell you, the petition was filed by Jatin Shrivastava, who could not participate in the second round of counselling due to the allegedly excessive counselling fee. His lawyers argued that the candidates are required to pay 30,000 to take part in counselling and an additional 20,000 for upgradation in the subsequent rounds. They contended that this fee is unreasonable and contrary to UGC rules and Supreme Court judgments. The petitioner also challenged the clause 1.5.1 of the counselling notification, which mandates that candidates must choose at least 15 NLUs to participate in the counselling process. He claimed that the high, non-refundable confirmation fee violates Articles 14, 19 and 21 of the Constitution and asked the court to restrain the consortium from charging such fees in the ongoing process. Although the court has agreed to hear the petition and fixed 2nd July as the next date, that is before the third round of counselling starts, it declined to stay the counselling process or allow the petitioner to join without paying the fee. The judge said that it would not be proper to disrupt the entire counselling process for one candidate. The petitioner has also requested that the collected fee be refunded until the matter is finally decided. And lastly, the Delhi High Court has directed the Delhi Jal Board to lay a new sewer line across the AIIMS residential complex to help prevent waterlogging in Green Park Extension and nearby areas. The court passed this order while hearing a petition filed by a resident Shailendra Bhatnagar who raised concerns about frequent flooding during rains. The bench comprising Justices Pratibha M. Singh and Manmeet Preetam Singh Arora noted that the issue needs urgent attention and that laying the sewer line is necessary in public interest. Initially, AIIMS had opposed the plan, arguing that the proposed line was to be laid on land owned by the New Delhi Municipal Council or the NDMC, and that the problem was due to faulty rainwater drainage, not a sewer issue. After NDMC was included as a party, a meeting was held with all stakeholders including AIIMS, NDMC, Delhi Jal Board and the petitioner. It was informed that during recent rains, there was no waterlogging in the area because of consistent cleaning efforts by the DJB. It was also clarified that the new sewer line would only be about 200 meters long with around 130 meters passing through AIIMS premises. Taking note of these facts, the court said that it had no doubt about the necessity of the new line. It directed the Jal Board and MCD to ensure regular cleaning and de-stilting of both the sewer and stormwater drains throughout the monsoon season to avoid waterlogging. The court also asked Jal Board's chief engineer to coordinate with officials from AIIMS, MCD, NDMC, PWD and the Delhi Forest Department to address any issues related to tree removal or other clearances needed for the project. Finally, the court instructed the Delhi Jal Board and the MCD to submit a report detailing the design and route of the sewer line and how it will connect Green Park Extension to Aurobindo Marg along the AIIMS premises. The court also stressed that the plan must be executed with minimal disturbance to residents of AIIMS residential campus and in consultation with the designated nodal officer from AIIMS.